We're going to have a very informal meeting today. I've asked Brian Zinn to speak about the recent Supreme Court case on Chapter 7 lien stripping. Greg Champeau is going to talk about a case that came out, about a month ago?
Yeah,
that we probably should know about. Richard's going to tell us about a case he had today. No? You're not?
Nope.
No? Okay, he's not. Greg will tell us about it. And then I'll talk a little about the Baker Botts Supreme Court case that came out a few days ago. So Brian, there you are. You want to get started?
Sure.
And then I'll tell you about some administrative orders we have.
We have these mugs. If anybody, whoever gives the biggest applause gets the free mug. Okay. Morty was, this guy Morty, he was having really bad financial difficulties, and he goes to the synagogue to pray. And he's a middle-aged guy, and he's been praying all his life. And he's in the synagogue, and he talks to God. He says, God, I've been praying all my life to you, and I've never really asked for anything. I really need to win the lottery. And I apologize if a lot of people have heard this before, but it's relevant to the case. He says, I really need to win the lottery. I'm behind on my car payments. Things are getting bad. And there's no response. He walks out of the synagogue. That week, the lottery comes and goes. Morty doesn't win the lottery. Goes back to synagogue the following week. He says, God, they have repossessed my car. I'm about to lose my job because it's hard to get to work. Would it be so bad for me to win the lottery?
A little bit of
so he's thinking, he's waiting for something, some sign, nothing. He walks out of the synagogue. Lottery night comes. Morty doesn't win. Goes back the next week. God, I don't know what else to say. I've prayed to you my whole life. I've lost my job. I'm behind on my house payments. My house is in foreclosure. I really need some help here. He leaves the synagogue. Lottery night comes and goes. Nothing happens. Goes back to the synagogue. He says, God, I've lost my house. My wife has left me. I've lost my car, my job. I don't know if I can believe anymore, have the faith anymore. I don't know what else to do. And he walks out of the synagogue. When he walks outside, there's this thunder and lightning from the sky, and a booming voice comes down. He says, Morty, buy a ticket. So the reason why I brought that up is because the debtor's attorneys in the Caulkett case before the U.S. Supreme Court didn't buy a ticket. They basically asked the Supreme Court if they could win, but they didn't give the Supreme Court what the Supreme Court needed, which is they never asked the Supreme Court to overrule Deuce-Smith. And because of that, and you'll see that 3 times the Supreme Court says, now mind you, they didn't ask us to overrule Deuce-Smith, and so they didn't rule for the debtors, so they didn't buy the ticket.
Is that one for each time they ask the question about whether they should overrule it or not?
So I don't know why they didn't. I actually read that at oral argument, the U.S. Supreme Court actually asked the debtors several times, and the debtors' attorneys refused to ask them to overrule Deuce-Smith. So we have this. What happened in Bank of America versus Caulkett is it's a Chapter 7 case. There's a second mortgage that is totally underwater. So the first mortgage was higher than the value of the house. And as people probably know, in the 11th Circuit here, we had a decision by the 11th Circuit saying in Re McNeil, and basically later on in couple of other cases, I think Follendor or some other cases, where they basically said, well, as far as we're concerned, DUSNIP doesn't prevent us from saying that a debtor can strip the second mortgage off of a house if it's totally unsecured. And that disagreed with almost every other circuit, so it went up to the Supreme Court. And the Supreme Court says you can't strip a second mortgage lien in a Chapter 7. That's wholly underwater. Now, Justice Clarence Thomas, is the one who gave the decision. And he starts out by pointing to Section 506. And under Section 506, that's the one that basically says a creditor's claim is secured to the extent of the value of the property, and it's unsecured to the extent it exceeds the value of the property. That's 506A. And then 506D says that a lien is void as long as it is not an allowed secured claim. So in other words, you could strip off a second mortgage if it's considered not an allowed secured claim. And everybody agreed that it was an allowed claim, so that wasn't an issue. The issue was, is it a secured claim? And Clarence Thomas basically said, looking at the language of the code, the plain language of Section 506, the debtors should win. That the plain language, that's what he said, the plain language of the code shows that the second mortgage is not a secured claim. Because 506A says it's unsecured to the extent it exceeds the value of the property. And he says, one would think that this is a classic case for application of the normal rule of statutory construction, that identical words used in different parts of the same act are intended to have the same meaning. He says, under that straightforward reading of the statute, the debtors would be able to void the bank's claims. Unfortunately, this court has already adopted a construction of the term secured claim. And then he refers to DUSNIP, where DUSNIP, he says, defined an allowed secured claim as any mortgage that is allowed. And they said, he said, they apparently said that it was ambiguous. The interpretation was ambiguous, and that's how they got to this point. But then he zings the court, the Supreme Court, and he says, rather than apply the statutory definition of secured claim in 506A, the court reasoned that the term secured in 506D contained an ambiguity because the self-interested parties before it disagreed over the meaning. So Clarence Thomas basically says the U.S. Supreme Court should not have ruled that that's what an allowed secured claim is in DUSNIP. And then he says, but the debtors do not ask us to overrule DUSNIP, but instead request that we limit that decision to partially as opposed to wholly underwater liens. And he says we decline to adopt that distinction because it's either secured or it's not. And then he puts a little footnote, and it's interesting that 3 justices dissented from the footnote. But he basically gives a scathing attack on DUSNIP in the footnote, and he says DUSNIP has been the target of criticism. He cites a Supreme Court case where he gave a concurring opinion. This is Justice Thomas. It says, collecting cases and observing that the methodological confusion created by DUSNIP has enshrouded both the Court of Appeals and the bankruptcy courts. And then he puts in the final sentence of the footnote, despite this criticism, the debtors have repeatedly insisted that they are not asking us to overrule DUSNIP.
Buy a ticket.
Then he talks about Nobleman. Nobleman is the case, it's the Chapter 13 version of DUSNIP. DUSNIP was where you had a second mortgage that was partially secured, partially unsecured, and they ruled you couldn't cram it down. I believe that if the debtors did ask them to overrule deuce-nip, we would then be able to cram down second mortgages in Chapter 7. Not only strip them off, we could cram them down, because that's what they said, that was the holding of deuce-nip. But nobleman is the Chapter 13 version of deuce-nip, and that's where there was an attempted cram down of a second mortgage. And nobleman says you can't do that in Chapter 13. But they were looking at a different statute, so Judge Thomas says we're not going to talk about, that's 1322B2. And that's a different interpretation of the word secured claim there. As far as I know, there has not been a Supreme Court case that talks about stripping off a second mortgage in a Chapter 13. I don't think that ever got to the Supreme Court, although it's been allowed by many courts, including ours. And then, in the conclusion, Judge Thomas says, the reasoning of deuce-nip dictates that a debtor in a Chapter 7 cannot void a junior mortgage under 506D. The debtors here have not asked us to overrule deuce-nip, and we decline to adopt the artificial distinction they propose instead. It is so ordered. So that's what happened there. Now, I don't know procedurally if another debtor can challenge this and take it back up to the Supreme Court and ask them to overrule deuce-nip. I don't know if that's going to happen. I don't know if mortgage companies are now going to try to take a Chapter 13 strip off up to the Supreme Court and get the Supreme Court to say you can't do it in a 13 either. If anyone else happens to know if you can appeal that type of thing and try and challenge deuce-nip again, you could let me know or speak up. So that's the first part of what I was talking about is Caulkett. The second part is what happens now with all the mortgage companies that have been stripped off in Chapter 7. Can they come back? Are we about to get hit with a lot of motions? Now, Paul was kind enough to send me a conversation, an email conversation between him and Steve Wilkes. I thought it was very good. And I'm just going to summarize basically what we think, which is you have to look at Rule 60, Federal Rule Civil Procedure 60, relief from a judgment or order. There are 6 different ways you can ask a court to void a prior order or judgment. 3 of them you have to do within a year. So if you're beyond a year, you wouldn't be able to resort to the 3 of them. So the first one is, as a grounds for relief, is mistake, inadvertent, surprise, or excusable neglect. That wouldn't cover here, so I don't think a mortgage company would be able to come in and say there was a mistake or something based on a U.S. Supreme Court ruling. I can't picture that happening. Number 2 is newly discovered evidence, but I don't think a Supreme Court ruling is newly discovered evidence. Number 3 is fraud, so that doesn't apply. Number 4 is the judgment is void. I think they're talking about the judgment in that particular case, and I can't see them saying that somehow it was void because of the Supreme Court in another case. Number 5, the judgment has been satisfied, released, or discharged, or it is based on an earlier judgment that has been reversed or vacated. But again, I don't think you can, a mortgage company come in and say, well, it was based on an earlier judgment that had been vacated. I don't see that happening. So they're left with number 6, which is any other reason that justifies relief. Steve Wilkes had said that he thinks that that the mortgage company would have had to preserve their rights possibly in the order, saying something like, this is the decision, but if somehow it gets reversed, the 11th Circuit decision gets reversed on appeal, that the mortgage company has the right to come back into court. But I bet you there are gonna be mortgage companies coming in on number 6, which is any other reason that justifies relief. I have not done the research as to whether a subsequent decision would constitute such a reason. Also, you run into other strange situations. What happens if the property has already been sold to someone else? Or what happens if the debtors have gotten another mortgage or refinance? So we have all of these potential difficulties. I really don't think that we're going to see much by way of any mortgage company coming in and trying to reverse it. But it's possible that they come in under number 6, Rule 60B6. Anybody want to say anything, contribute?
I was amazed after listening to what Scalia said, and because he wrote the dissent in Dusnip, and he had much invited the debtor in this case to take a run at my reasoning,
Right.
and support my. Everybody's chuckling in the background of this case.
Right.
Good transcript. You want to read it too. It's a quick reading. And Justice Kagan asked it. It was amazing.
Right. So, yeah, they didn't ask them to overrule it, so.
At this point, Brian,
Mm-hmm.
if I remember reading this case well, they held that under 506D, because the claim was already an allowed secured claim, that they could not strip.
That's
Because
Dusnip.
there was no, well, that's also this case. They based on Dusnip. And if I'm reading it correctly, and they went to 501 or 502 and said it's been allowed. Nobody objected to it. It's been allowed by operation of time, effectively,
Right.
and because nobody objected, and therefore it is allowed as a secured claim. What would happen if you went back to when you started and you said, instead of starting under 506 to strip, you go back and you say, I'm objecting to the claim because it's unliquidated. It's unliquidated as to how much of that claim is secured and how much of that claim is unsecured. Okay, at that point, you would then have a rendition under 501 or 502C to make that determination. And now you would have an order that tells you how much of that claim is secured and how much of it is unsecured. And then you could strip off the unsecured portion because there's already been an order determining that.
Well, the problem is that this court said that the Caulkett court said that Dusnip defined an allowed secured claim as any mortgage lien that has been allowed. So they don't talk about how much is over the value of the property and how much is not. I'm sure the Caulkett case, the Caulkett court agrees that this should not be an allowed secured claim. But they said they're bound by the prior decision because no one asked them to rule on it. Someone else had their hand up.
I was going to point out that both Dusnip and Caulkett and McNeil were no asset sevens, so there would never be a claims bar date. There would be no claims allowance process at all. And that's sort of what as part of the reasoning in Dusnip is that because there's no claims allowance process, there's no sort of vehicle for this to be ferreted out, and so you rely on what they call the free code practice that the liens pass through Chapter 7 unaffected.
Okay, that's a good point. There are no claims submitted and no allowance process. So,
But it's troubling to have the identical phrase in two parts of the same statute mean something different. Because that's what it has to mean. I mean, they had to go construct something in the last subsection. It's different from the first subsection.
right. Well,
And there was a pre-code, and I'm trying to get the name of it now, because I cited it in the brief I wrote, another case we had. There was a pre-code concept that said what undersecured was, and that the lien wasn't allowed at another security under the Act, and even before the Act, under English law. So, and it doesn't make any sense.
It means to reach an end, We kind of reconstructed it, came up with the decision, and figured out how they would. justify it going
Right. Anybody else? Okay, thank you.
Get your money. Before we get Greg up here, I just wanted to bring to your attention a few administrative orders that have come down. I try and forward these when I get them, but I don't always get a chance to because I get just too many emails in a day. Most of them are junk and spam, and people tell me, never mind, I'll leave that out. But we have Administrative Order FLMB 2015-1, which deals with, it's an amended order prescribing the procedures for mortgage modification mediation, signed on March 9th by two judge gentlemen. And it outlines some of the procedures that need to be followed. I'm not going to read it all to you. It's 17 paragraphs, but you can find it at the court's website, so I just want to bring that to your attention. If anybody is looking to do any mortgage modification mediation.
What did you say the number was on that?
It's 2015-1. And if you want my copy, I'm happy to give it to you. Another one was 2015-4, which deals with requiring photo identification by unrepresented parties. And the basis for this administrative order was to prevent abusive and fraudulent bankruptcy filings. So unrepresented parties are going to have to provide photo identification at the time that they file their petitions, whether they file them in person or by mail to the clerk's office. Debtors are going to have to sign the petition initiating a case prior to submitting the paper to the clerk. And any person bringing a petition to the court on behalf of an unrepresented party must also provide acceptable photo identification at the time of filing. So you can use a U.S. government issued photo ID, state issued photo ID, or an identity card issued by a national government authority. For example, driver's license, passport, military ID, or resident alien card. And then in addition to that, each unrepresented party has to submit a statement of Social Security number listing the full Social Security number of each debtor when they file their petition. So that's 2015-4. Doesn't really affect people here because, if you're doing debtor work, you're representing them. But if anybody ever comes in, you counsel them, and then they say, well, I'm just going to do it myself, you may want to bring that to their attention. 2015-3, new procedures for filing papers under seal. That was issued May 19th, 2015. Basically what it says is that if a party seeks to file a paper under seal, the party shall electronically file via CMECF a motion for authority to file the paper under seal using the motion to seal docket event, and then submit a proposed order using the order submission procedures posted on the court's website. And the moving party is not to file the paper requested to be placed under seal until the order granting the motion is entered. Apparently, some people have had problems in the past where they attach what they want to file under seal, and it's out there.
Brilliant, isn't it?
Yeah. So.
Please let me file this document attached as Exhibit A.
Yeah.
Under seal.
And then once the motion is granted, the party can file the papers under seal using the sealed document docket event, which makes it invisible to outside users. The only people that will be able to see that would be the court clerk. So those are a few of the hits and highlights in the last couple of months.
New chief judge. New chief judge.
Oh yeah. And starting October 1, Judge Williamson is going to be the new chief judge for the Middle District of Florida. So I don't know if there's going to be a ceremony or anything to that effect. I don't know. Do they usually make a big hubbub of it? No. Okay. So Judge Williamson will be visiting us once a year, hopefully, once he takes over that position. And then real quickly, I don't know if anyone saw the Baker-Botts U.S. Supreme Court opinion that came out a few days ago. Supreme Court ruled that an attorney attorneys are not entitled to recoup the fees that they incur in defending a fee application. What's that? Defending. So, there's a lot of concern by people representing debtors that creditors may object to fee petitions as a form of leverage in the underlying case. There's some good commentary on Law 360 if anybody has access to that. If you don't, I'd be happy to share it with you, but that came out, and basically the court held that Bankruptcy Code Section 338 does not authorize compensation for the costs counsel or professionals bear to defend their fee applications. And all this was over a $4.2 million bonus that the law firm sought based on a previous $124 million fee award. And this law firm spent...
Gee, I think our hearts would be
Yeah.
great.
They spent $5.2 million fighting over $4.2 million. So I don't think anybody's going to
Well,
be...
they were hoping to get paid that.
Yeah.
Not bad, they took a $9.4 million loss.
Yeah. Well, they were awarded the $4.2 million. They just weren't awarded their fees for fighting that fight. So that's the Baker Botts versus Sarco LLC, and it was on the 15th the decision came down. So, and then with that, I'll let Greg come up and share some other interesting case law with us.
Thank you. This is a case that some of you may be familiar with. It's relatively new. It's from Judge Williamson, our soon-to-be Chief Judge. And the case is In re Metzler. The actual case number is 812BK-16792. I can circulate the site if you want it. And it's a memorandum opinion that deals with the surrender of real property in both the Chapter 7 and the Chapter 13 context. And it's of particular importance to both practitioners in 7 and 13 and those folks who might do state court defense of foreclosure actions. And what the court did is they analyzed the import of what surrender means under 521 and 1325. I'll give you the kind of background of the Chapter 13 because the Chapter 7 is a little bit convoluted, but we get to the same resolution either way. In the Chapter 13, that's the Metzler case, there was a pre-petition foreclosure suit by Wells Fargo. There were several iterations of the Chapter 13 plan. The first plan was a maintain and cure. Later, they changed the plan again. And then finally, they proposed a third amended plan, which allowed for the surrender of the home back to Wells Fargo. That case was confirmed by the court. And then post-confirmation, Wells Fargo went back to state court to reinitiate the foreclosure action. And the debtors affirmatively and actively defended the foreclosure action. They filed affirmative pleadings, responsive pleadings. They defended the action like you would normally do in a state court foreclosure defense. The question before the court was, what was the legal import of surrender under the terms of the Chapter 13 plan? And Judge Williamson looked to some language. First of all, he made the relevation, or basically announced that it wasn't a defined term under 521 in the code. So there wasn't any direct language you could go to or any statutory authority that could give us a defined definition of what surrender is. He first addressed an opinion from Judge Jenneman that said surrender was not delivery, so you didn't actually have to go and deliver the property or execute a deed or what have you. You didn't have to go that far. But ultimately, the decision was made that surrender meant that you could not impede the creditor's ability to go forward and to basically take back their collateral through foreclosure means. So if you were actively defending that in state court, then you got a problem. Because what the court did here in the Chapter 13 is they revoked the confirmation order. The Chapter 7 case was a little bit different factually. the debtor in Chapter 7 didn't even know that they had an interest in the property. It wasn't scheduled. The trustee didn't know about it because it wasn't scheduled. So there was no intent there necessarily to defend the foreclosure action. Somebody had actually stepped in and defended the foreclosure action without the debtor knowing it. But really, I think what you need to take away from the holding in the case, and I think probably the judges will take a uniform stance on how they're going to rule on these issues, probably in line with the way Judge Williamson did, is that if you're going to surrender, either under a Chapter 13 or in the statement of intentions in your Chapter 7, you better not go over to state court and actively defend the foreclosure action. Because you could open yourself up for sanctions, or you could, unwind your confirmed Chapter 13 plan. I guess it gives you a new dimension when you sit down with your clients and you figure out exactly what you want to do. Maybe it's worth, not surrendering the property and not claiming the super exemption to give them the ability to go back to state court and defend the action. You might want to contemplate how you want to handle it in the Chapter 13. Because once you disclose that you're surrendering the property, once you list it in the statement of intentions, or once that confirmed plan is beyond the appellate period, then you're going to be living with the decision to surrender. And if you go back to state court, you might open yourself up to some problems.
She
Melissa?
ruled upstairs in Dukes today, though, that if it was listed as pay direct and you were keeping the property and then you walked away, it's not discharged.
Apples and oranges. Because this is not a matter of discharge or not.
Right.
This is a matter of affecting the creditor's rights in state court. So if you're impeding the ability of the creditor to come back and do that,
Right, but
then
if you turn around and want to surrender later, you have to go back and amend the plan now.
yeah, that's ideally, based upon what the decision is here, yeah, I would do that to CYA for certain.
Yeah.
Because ultimately, and let me give a little bit of the background today, Judge Delano issued her opinion today in the Dukes case, and I'm not going to go into the specifics of it. You folks can talk about it if you like. But that was a case where there was a direct pay proposed under a Chapter 13 plan. Plan was confirmed, plan was paid off, discharge was entered, and then sometime later, the secured creditor came back and argued that a direct pay was not provided for under the plan, basically. And Judge Delano issued an order today basically holding that very premise, that if you are paying direct, that it's not provided for under the plan and not subject to the discharge. So you might have a problem with cases where, and I don't know how actively the creditors are going to be on this, but Suncoast brought this one, so I imagine Suncoast, knowing their past and how aggressive they are at collections, will probably look to go back and revisit some of these old cases that were pay directs, where they were later surrendered property and the properties were foreclosed upon.
Doesn't that help them if you pay direct? Doesn't it reduce the time when they're going to get their funds from they might went to the trustee?
I pay directs, and I think the real issue here is that we can't propose a plan any longer to put any type of special language in there that will limit the debtor's ability to be liable on this debt. We have to use a form plan, and the language of the form plan doesn't provide any protection for you either got to do A or you got to do B.
I think that's
And
something due process.
It's an issue, and I think the form plan that we're required to utilize kind of puts the debtor in a bind. Either that, or like Melissa said, we're going to have to go back in a number of these confirmed plans, and if they have changed their intentions, we better get an order changing that. And that brings, and I think there are a couple of, you had one before Judge Delano last month, where she had to take it under advisement as what to do with the mortgage creditor's claim now.
I don't know ruling on that one yet either.
Yeah, I know, it's still kind of up there. So you got some things to think about. I know Mr. Hollander had expressed that he'd probably be appealing the decision in Dukes. The order's not out yet. She just ruled from the bench today. But, give some serious consideration to, if you're going to surrender or not, and what kind of implications you'll have in your 7 and your 13, right?
Greg, it's my understanding that in some of the other jurisdictions, it's standard practice to pay the mortgage company through the trustee, even if you're not behind.
Yep.
Do you know, did Judge Delano's decision touch on that at all? Like if that would be considered provided for?
Yes.
Well, I think, yeah,
That's provided for.
if you make a specific provision within the Chapter 13 plan to pay, you know, via the plan, then I don't think there would be any argument that that would be provided for. It's the direct pay mechanism where you're not affecting their claim at all. You're just paying directly that was deemed to be not provided for under the plan.
Understand something though, you
Maybe
just had an
10%.
11% increase to the cost.
Right.
Maybe that extra
And it
increase is
does-
worth it.
It does delay it delays the bank in the payment too, I would think.
No.
Because it's gotta go through the trustees.
Yeah, but adequate, I mean, if you're paying it through the plan, you've got your monthly payment, the trustee's processing is usually fairly quick in those
Yeah,
types
but I
of
mean, I'm
things.
saying, it still delays the bank, and so why wouldn't you put it through the plan other than the 11%?
Right. That's what I'm thinking.
It limits their ability to come back later and make that argument.
Sure.
For sure.
Yeah.
And you may want to, I don't know, if you put language in the plan that changes the due date on the payment to the bank,
I don't think
so that they're not, oh, is there under default?
Yeah, that's a problem with dealing with this model plan. And there was some discussion that I spoke to Mr. Waggy about, is that the national form Chapter 13 plan has become a little bit derailed. They're not pushing anymore for a standardized plan for everywhere. It appears that we're going to be able to retain our local plan to a great extent. There might be some variations and change in language, but it appears that the national formalized Chapter 13 plan has lost traction. So we won't be looking at something entirely alien to us. We'll be dealing with essentially our plan with some variations in the provisions. So nothing's definite yet, but it seems to be trending that way. Anything else?
That's the Metzler case?
I'm sorry. Metzler was 8:12-BK-16792-MGW. Judge Williamson's opinion.
Thank
And it's worth a read. I mean, it's fairly straightforward, but I think it's more on the front end when your clients come in to counsel them. Okay, do you want to stay in the house for maybe another, 6, 8, 10 months? Well, if you want to do that, the trade-off is you're not going to get the super exemption. You're going to have to, claim it and retain it and claim it as exempt. So is $4,000 or $8,000 in the joint case a good trade-off to stay in the house? In Chapter 13, I think you got to be diligent on knowing what your plan's going to provide for a confirmation. Otherwise, you're going to have to be amending the confirmed plan, and depending on how Judge Delano rules on how to treat those, the whatever deficiency balance might be for the creditors, you might have some implications on what you might have to pay to the unsecured creditors under an increased or reduced dividend. So, just something to bear in mind. Oh, thank you.
Does anybody else have anything they'd like to share for the group? No? Well, then we're adjourned. Our next meeting will be July 23rd. Thank you for coming, everybody.